So with me for this session I have Seok and Meng, and we're going to be exploring the world of mixed mode dispute resolution. And just before we do, I thought I'd set out what we understand mixed mode dispute resolution to be. So essentially when we're talking about dispute resolution, we look at facilitative processes such as mediation, advisory processes, for example, neutral evaluation, conciliation, and expert appraisal, and then determinative processes such as arbitration or private judging, for example. And basically mixed mode typically combines two or more processes from these three categories, right? And it usually mixes categories. So now I'm going to turn to my guests here today and begin by asking each of you, what's your experience with mixed mode dispute resolution? What sort of processes are people using?
I would say typically one of those, the most common, is what you mentioned earlier about friendly negotiations, discussions in good faith between both sides. The management, it could start, they could state in the clause, perhaps at a more junior level at the working group, and then escalation to senior management. And if all that fails, then either it's arbitration or litigation or something else. But there are issues with those sorts of clauses, as we all know, and they are not as structured as, say, an arbitration mediation arbitration clause or a MEDARB clause or other, where you set specific timeframes for when you would go to arbitration or litigation or something more determinative.
So Nadja, thanks for having us, and it's a real pleasure to be doing this with Seok because we happen to have a protocol called the AMA or ARB protocol with SIAC. So we are sister companies, so they are much more established than we are. So we're very privileged to have this protocol with SIAC, where parties can start an arbitration, basically get a tribunal constituted, and then you have a pause of about 8 weeks where the matter comes transferred to SIMC, where we take over the matter, so there's clear separation.
Separation of institutions and
individuals.
Practitioners?
Yes.
Practitioners.
So they would have appointed the arbitrators, and then when the matter gets transferred to us, we will not appoint the same arbitrators, obviously, as mediators, but we'll appoint independent mediators to look into the case and help the parties to mediate. If the parties are able to mediate successfully, wonderful, the matter gets transferred back to SIAC, where that mediated agreement can be registered or written off as a judgment, as an arbitral award, where then it gets enforceable under the New York Convention. If it doesn't get mediated within a short time of 8 weeks, and so if you think about it, it's really a very, very short pause of the process, then it gets transferred back to SIAC, where the arbitration will continue as if nothing has happened. It hasn't even missed a beat in a sense. So that's the arrangement that we've had with SIAC, and I think with great success.
So Meng, you mentioned separate institutions and separate neutrals. Now some people might say, it's more cost efficient just to have the same person as arbitrator and mediator. Why go to that trouble?
I guess from our experience, if you have the arbitrator also acting as a mediator, there are some challenges, because in a mediation process, you would have private sessions, generally, where the mediator will meet one party privately and then the other party privately as well. And what's said within those meetings are completely confidential. For an arbitrator, it would be very difficult, I think, for the arbitrator to be meeting one side privately without the other side being present, because that might address or that might affect the neutrality of the arbitrator, and the parties might have concern. That's one aspect of it. Then the second aspect of it would be that, and you know, so we and I have been in-house counsel ourselves, and when we enter into a negotiation, when we enter into mediation, we would not want especially the arbitrator, to know what our bottom lines are. We would, even with a mediator, we may not always review our bottom lines, but with an arbitrator who might, after the mediation, might actually decide on my case, I certainly would not want the arbitrator to know my bottom line. So to have the arbitrator then act as a mediator, I would definitely not be very open about, what my options are, what my interests are, how I would see the matter may be resolved, because the arbitrator might just adopt my bottom line, and I wouldn't be in a very good position.
Seok, as CEO of SEAC, a lot sort of comes across your desk. What other, apart from the AMA protocol, which you've put together with SIMC, what other sorts of mixed mode procedures have you come across?
Typically, back to the one I mentioned earlier, the friendly discussions one, we still see a lot of. We also see parties, and these are the pathological clauses, electing for litigation for certain things, and then saying arbitration for other things, or if all else fails, or leaving it rather open in the drafting of that clause, which leads to confusion and room for lawyers to sort of argue further and make more money.
So essentially, I mean, the key is you can really put together these processes any way you want, right? Something I call DYOP, do your own process. But you're coming back to this point about structure. It's particularly where you've got a clause, it's got to be drafted very tightly. It's got to be very clear, because I imagine you could have issues, for example, if you've got negotiation followed by mediation, followed by some expert appraisal input if parties want. We've got other examples with dispute boards, right? Arbitration coming in later. Sometimes there may be a question, well, which law applies to this clause? Particularly if in a jurisdiction you've got arbitration legislation, you've got mediation legislation, you've got the general law as well. And that could become very lucrative for lawyers, I imagine, but very messy, right, from a practical perspective.
Extremely messy, and that's why we say keep it simple, always. And that's why we have a model clause. The ArtMedArt, SIAC and SIMC have come up with an arbitration model clause as well. And it's very short compared to the reams of paper we've seen, pages and pages of the dispute clause, which gives more opportunity for parties to challenge that and to find ways and loopholes and arguments. I would say parties have been overwhelmingly positive and receptive and open to the ArtMedArt protocol. Every time I've spoken about it, and this came in November 2014 when the SIMC was first launched. Yeah. So it's been 7 years. I can't believe it. And at the time, so we were. It was very unfamiliar to most parties. Mediation itself was and still is, to a certain extent, quite unfamiliar to parties. And the ArtMedArt protocol was even more so. And the concept of a seamless integration of these two types of dispute resolution was something new, and in-house counsel, general counsel, liked it because of the certainty it offers them to bring back to management, to say, if the mediation fails, it doesn't go well, then there's an automatic default to arbitration. And the fact that you start the arbitration first under this protocol tends, in many cases, to bring the other side to the table. It shows that you are serious, and that if the mediation doesn't work out, and through the mediation, each side would have a pretty good assessment of the strengths and weaknesses, relative strengths and weaknesses of their case. What the weaker side would stand to lose if, in the event of an unfavorable arbitral award against them. So there is some motivation in that sense to be serious about it. And definitely the time and cost efficiency of this process with the very clearly defined timeframes is an added advantage, because many multinationals have gone through those sorts of undefined friendly discussions in good faith without a long stop date. And then there's always the difficulties if the other side insists on in-person meetings, which may not be possible because the relevant person, the CEO, is always not available. And so this drags things on, and you are bound not, you can't bring things to the next phase, to the next level, whether it's arbitration or litigation, until you've had those friendly discussions. So that is a big downside of an open type of clause. And that's why the Mad has been very well received, actually. Because it sounds like
it offers clear triggers to move people to the next phase or the next part of the process.
And it's very flexible as well. People like the flexibility that it gives, because although the default procedure is for mediation to start after constitution of the tribunal, really, and we've seen this in practice as well with the Mad cases, we've seen that you really can bring it at any stage. It could be even after substantive submissions, and that could be a strategic thing as well, to do it later rather than sooner. And even if it doesn't work out, at least you would have narrowed down the issues, hopefully through the process of mediation, so that when you get to arbitration, you again save costs. And it isn't, I have to say, many people say arbitration is expensive and slow, but the SIC has many time and cost saving mechanisms that could work together with mediation.
So Meng, here's a question for you, because it's linked to the shifting landscape of mediation, particularly international mediation. So you've got the AMA protocol, right? And you've been talking about how it's been well received, and how it's structured, and how it allows parties to take advantage of the New York Convention, because you'll end up with a consent arbitral award. But now, of course, we have the Singapore Convention. And some people are saying, what will the impact of that be? A convention which basically offers you direct enforceability of mediated settlement agreements. What will the effect of that be on the dispute resolution landscape generally, but in our conversation on your protocol? Will there be a need for the AMA in years to come as the Singapore Convention gains traction? What do you think?
Well, I think the Singapore Convention was a fantastic start to promoting mediation at an international level. I mean, when it was signed, we had 40 over countries that signed, and right now we have, I think, the last count was 50 over countries that have signed, with slowly countries ratifying. But it will take years. It's going to take a long time. Whereas, as far as AMA is concerned, as far as our protocol with SIAC is concerned, that's immediately enforceable. So while the Singapore Convention is important, it is the long-term play of how mediation, it's a long game, and how it will slowly take traction. I mean, the New York Convention, I think, took 40 years before it finally reached 160 countries. So it will take time. And of course, we're in the middle of COVID. It has sort of delayed this whole convention a little bit by a year or so. So we do see that it is a journey that we'll have to go on. And meanwhile, parties do need a more predictable kind of solution that they can rely on as far as enforcement is concerned. Yeah, certainly I think as far as mediation is concerned, especially for complex commercial disputes, it is still relatively new. And I think Seok brought up a good point that when the parties bring it to arbitration, it focuses the minds of management, of the outside counsel, of the general counsel, that this is something they need to sort out. if you do not have that, sometimes at mediation, it is just difficult to get the attention and to get the resources behind for both sides to actually resolve the issue. So the advantage of starting off with arbitration is that both sides have to spend some money to get it before SIAC, and with the constitution of the tribunal, then both sides are kind of gearing up for the arbitration. And at that point in time, it usually helps the parties to say, okay, what are our other options? Right? So that's one thing that we've seen. But having said that, we have also had cases where it is not an AMA case, it is a pure arbitration case, but in the midst of the arbitration itself, the parties decide, usually with the consent or with the advice of the arbitral board, that it is probably a good idea for the parties to consider mediation.
We've been talking a lot about mediation and arbitration. I'm wondering about any other hybrid mixed mode variations you've come across that perhaps involve expert appraisal or something else.
We don't have many expert appraisals in SIMC. I think we only have had 2 cases so far. But what we have seen, is, as far as mixed mode is concerned, is the mediator being asked by the parties at the end of the mediation, at the end of coming to a settlement terms itself, to add on an opinion of some form, non-binding, but an opinion of some form to help the parties to bring this settlement agreement to their boards. So it's all very confidential, right? The settlement agreement is agreed in principle, not signed, but then both sides would have requested the mediator to, can you please help us to structure and advise based on what you see as the party's strengths, weaknesses, combination of that, the best practices, etc. Then based on your expert opinion, we would then bring it to the board. And we've seen that with success as well, in that the board would then be able to accept the settlement agreement together with the mediator's opinion. This is very unusual. I've only seen it in really a handful of cases, but that is an interesting development that I've seen.
Yeah, so mixing facilitative and advisory processes. And I'm going to throw this back at you, Meng, because doesn't that example that you've just shared sort of fly in the face of the separation that SIMC and SIAC have tried so hard to structure through your AMA protocol? Because if I've understood you correctly, you've got the same neutral, the mediator, shifting role. And I can see the benefits. It's cost effective. You've got a mediator who's already familiar with the dispute, offering some advice. But isn't there a risk, for example, if one party becomes unhappy with the outcome down the track, that they might say, oh, bias or something else?
Yeah, I think we are pushing the envelope there, right? In terms of coming up with a new way of helping the parties to resolve their dispute. But I think the difference between sort of having a mixed arbitrator becoming a mediator, and that example that I gave about mediator giving an opinion, I think the difference is the timing, because the mediator actually plays the complete role of a mediator for the 2 parties to decide on how they want to settle the issue. It's only after it's settled that the mediator then, on the request of both parties, is completely transparent, on the request of both parties to say, could you help us by putting up an opinion? So I think that the timing is a little different, and that makes a difference.
Seok, we were talking about the expedited procedure in arbitration. Can you say some more about that, please?
Yes, it's a fast track, 6-month arbitration. There are certain conditions. One of these, there are 3 basically. One of these is that the sum in dispute has to be under 6 million Singapore dollars, or the parties must agree. to the fast-track arbitration, or in cases of exceptional urgency. You can apply under any one or more of these limbs. The other sort of tools we have in the toolkit at the SIEC to save time and costs for parties are the consolidation and joinder procedures. That's when related cases are heard together to save time and costs, or when you join related parties in the same forum. And it's entirely flexible because these procedures can be deployed either before or after the mediation. And those would be strategic considerations. There's another one called the early dismissal procedure, where parties can apply to have frivolous or vexatious claims or defenses struck out early on in the arbitral proceedings on grounds that, on the basis that the manifest lack of legal merit or manifest lack of the tribunal's jurisdiction. And again, this one can be deployed before or after the mediation. So I had earlier on mentioned the emergency arbitration procedures we have, the fast track expedited procedure, consolidation and joinder, and early dismissal, which can be deployed in combination with the ARB-MAD-ARB protocol at any point in the proceedings. So parties should really consider, and that is one of the advantages, again, of this seamless integration between two institutions, and having this ARB-MAD-ARB protocol as one of several tools that you can use.
So thank you. This has been such an enlightening conversation, and I think what it's really brought home to me is that the idea of mixed mode is not new, right? It's been around forever. ARB-MAD-ARB is not a new mixed mode procedure. It's been around for a long time, but what is new, and this is something that both of you have mentioned, is the way it's been streamlined here and the way that the institutions work together to offer structure along with the general law. And I think that seems to make a really big difference in the Singaporean jurisdiction. Thank you both for your time.
Thank you.
Thank you. Thanks for having me.